what happens when we move our client program from the 7:30 in the morning to noon. We appreciate you all being here. We usually have introductions of each other, but given the size of the crowd, and I don't want to cut into Quinton's time, so I think we'll just get started. And we have an hour program for you, and then Quinton and I will be available for a bit after lunch if you all have some other questions. And if you have questions during our presentation, feel free to just raise your hand and we can have a discussion about whatever concerns you may have. I'm going to talk first about harassment and harassment training. And this topic really kind of got into my head when I read about the fact that the EEOC's task force had issued a report finding that training, that there was no evidence that anti-harassment training prevents harassment. And you just kind of go, what? I mean, if you've dealt with the EEOC for any amount of time, and if you've had the pleasure of dealing with them in negotiating consent decrees and the like, one of the things they always require in a consent decree is a commitment by the employer to do training, and you have to prove that you've done training. You have to submit affidavits, you have to submit reports. So when they come out, when their task force comes out and says there's no evidence that training prevents harassment, you kind of go, what have we've been doing with you folks all these years? So that prompts one to look at the report and see what the task force actually looked at. And that's primarily what I'm going to talk about. Before we get started though, show of hands, let me ask you all some questions. Who, and I know there are multiple companies represented here, and there are a few, in some cases, maybe more than one representative from a company. So of your companies, who has some type of anti-harassment policy that is distributed to employers? Show of hands. And how many of you have had some sort of anti-harassment training for your employees within the last year? Okay. You know, ideally more hands would go up, but I understand. And of those who have had training, has it been in person, live, or is it some sort of online training? Online. Okay. Many companies these days do have some kind of online training, and the EEOC, of course, discusses that as well.
Excuse me. Oh, sure. Coming in.
Yes, you're late. Hello, Dolores.
Now understand, she's late, but I was being sick.
Periodically over time, and for those of you who are old enough to remember Anita Hill and all that flat back in the 90s when Clarence Thomas was nominated for the United States Supreme Court, that was an event that really brought to the forefront harassment. In this case, it was sexual harassment. And periodically, things like that happen, events happen that bring a lot of attention to harassment. And by the way, since the Supreme Court first recognized sexual harassment as prohibited conduct under Title VII in this Supreme Court case of Meritor Savings Bank v. Vinson, the concepts of sexual harassment really have been applied to other forms of other protected statuses, I should say. And you all raised your hands about your policy, having a policy, and ideally the policies that your company have make it clear that it's not limited to just sexual harassment. It prohibits harassment based on age, based on gender, based on race, disability, those other protected statuses. And that's long been the rules of the road for employers, that you don't just look at sexual harassment. But one of the things recently that, you know, in the news was a sexual harassment issue of Gretchen Carlson settling for $20 million her lawsuit against Roger Ailes, the head of Fox. And so that's one of those, you know, when you see a $20 million verdict, it's that kind of event that really brings attention again to harassment. And by the way, one of the things that has come out of that lawsuit and that settlement is that she apparently had a number of recordings of Mr. Ailes engaging in inappropriate verbal solicitations for sex and other things. One of the other women who came forward had said in the past that Roger Ailes had said things like, if you want to play with the big boys, you have to lay with the big boys. And there were things like that Gretchen Carlson recorded on her cell phone as she was meeting with Mr. Ailes. And so one of the things that can be expected probably is that there will be more recordings, surreptitious recordings in the workplace where someone is engaging in inappropriate conduct. And New Mexico is a one-party consent state for recordings, which means that, you know, I can go into someone's office, not that I would want to, but, you know, I can surreptitiously tape record another party without them knowing and without me having to tell them that they are being tape recorded. So perhaps expect more of that down the road. So, in its infinite wisdom, in the EEOC's task report, one of the things they looked at the notion of the percentages of harassment cases or claims or complaints that still happen even after all these years of Anita Hill and all these cases, all this publicity about harassment, all of the EEOC's efforts about the need for anti-harassment training. They found that there's still a large percentage of some protected group members in the workplace that feel that they are being harassed or report having been harassed for one reason or another. And some of those statistics are quoted in the materials. And, you know, and you have to take at face value. The report said they used all of these statistical studies. They had some of their own studies done. So there's probably some reliability, I would think, in those numbers. So bottom line is there's still a large amount of harassment concerns, complaints, charges, gripes, problems going on out there in the workplace. And in fact, the EEOC said that fully a third of the roughly 90,000 charges that the EEOC had for fiscal year, I believe it was fiscal year 2015, fully a third of those charges had some element of harassment based on some protected status. Again, sexual harassment or race or age or gender, etc. And one of the findings of the task force was that in many cases, the targets do not complain or report the conduct of the harasser. And so that was one of the things that the EEOC focused on, is what can be done to make it more, to encourage people to report problems that they have rather than just suffering in silence, with the result that the problems tend to get worse if not reported and addressed, or people just leave the organization to the loss of the employer. So that was a significant finding, I think, from the EEOC. The report also identified, and by the way, I don't expect you to wade through the entire report with attachments and appendices, etc. It's over, or close to 100 pages, I guess. And I thought a lot of it was, quite frankly, what I said to my partner, Quentin, it was kind of touchy-feely, psychobabble stuff. But there were some real nuggets there, and that's really what you have to kind of sift through to try to find. And one of the things that I thought was useful for employers that are still facing harassment issues is that they found a number of factors where that might encourage harassment or not discourage harassment in the workplace. And those factors are listed toward the bottom of the page. of page 2. For example, the homogeneous workforce, where, for example, there's maybe a single female employee among otherwise male workforce. And we've had situations like that with, for example, a construction site where there may be a single female crane operator or truck driver or something like that. And that, because of the otherwise homogeneity of the workforce, this person is sort of the odd person out and is the subject of harassment. Workplaces where some workers do not conform to workplace norms, such as a feminine acting man. And we've had that situation again in a construction site where a man is not the, oh, Matthew,
How's
you
it
of all
going?
people should be on
Oh,
time.
packed house.
How are you?
Fine.
This is Matt Sanchez. He used to work with us, so I can harass him as a case. There may be some teeth in the back. So, workplaces where, again, a construction site where there's sort of a feminine acting male working in an otherwise heterosexual acting environment can cause problems. Workplaces where they are so diverse, sort of the other situation, that they have significant blocks of workers from different cultures. And I did an investigation a few years ago. It was so interesting. There were African workers from different countries in Africa that were actually working within this organization. And they were sort of this block unto themselves and caused some problems in the workplace, not because of the way they were treated necessarily, but because of their sort of their just acting, excluding others and having difficulty interacting with their coworkers. So that type of dynamic can also cause problems. Workplaces where there are many young workers, the EEOC has focused on that because sometimes young workers can either be unaware of the consequences of their actions, or they may be targets for harassment. And the EEOC a few years ago had this as a real priority because they felt that young and female workers in particular in the fast food industry were being targeted. And we had a very broad, long-running battle with the EEOC with that type of scenario. Some of the other scenarios that can cause problems where there are high-value employees who may believe that the general rules of the workforce do not apply to them. That's sort of the Roger Ailes situation, where you have that key person who is sort of viewed as being, and probably views themselves as being, really, the rules apply to someone else, but not to them, because they're so critical for the organization. Workplaces with significant power disputes where there are, or disparities where there are the supervisors and managers and then large groups of subordinate employees, and so there's this great power disparity can result in harassment scenarios. Some of the other ones, isolated workplaces where harassers have easy access to coworkers. We had that situation too, where janitors who worked at night when the building was empty, they were isolated, there was a small group of them. There's maybe a female janitor and the harassing male janitors. I'm not saying that's always going to be the situation, but that type of isolated workplace can create problems. Sometimes too, where the workplaces consist of work that is just sort of routine and repetitive and monotonous, call center workers, or people who are just, they can use half of their brain to do the tasks that they are supposed to do for their job, and then that sort of leaves them with the idle brain as the devil's playground, so to speak, and so they start finding other ways to fill their time or amuse themselves, and that can result in some some risky scenarios. So in looking at all of this, one of the things that the EEOC task force did was make recommendations about training, about having a policy, and accountability. And you know, they use the word they use this word holistic. I don't even know what they mean by that, I guess, but they say, you know, you have to look at your workforce holistically. And I think what they really are saying is that you look at in terms of supervisors and managers, for example, what is the leadership of the organization? You look at it in its entirety. What is the leadership like? Is it an organization where the phrase fish rots from the head kind of comes to mind, where the leadership is not good leadership, it sets bad examples, it doesn't set good examples, and the subordinate employees get the idea that, well, if Roger Ailes is doing it, it must be okay, so, you know, have at it. And that kind of looking at the, failing to look at the whole organization and seeing what the leadership is like can be a dangerous scenario for employers. So that's one of the things that they talk about. Do you look at your workforce and do you look at your workplace, and keeping those factors in mind, see if there are those risk factors that may be creating scenarios that you think everything's fine because, you know, all the janitors sat down and had some video training on harassment, but there's not really that targeted training, or there's not really appropriate supervision of those types of workforces. So again, looking at the risk factors, are some of those applicable to your workforce? Are managers and supervisors held accountable? I mean, decades ago, I was working for a company, or representing a company, and one of the things they put in the supervisors and managers evaluation was how people are treated in terms of whether discrimination or harassment concerns are created. And so, you know, that's not a new concept for supervisors and managers to be held accountable for what the people that they are doing, what the people that they supervise are doing in the workforce. I mean, managers and supervisors, if they hold that title, they should be aware of what their subordinate employees are doing. Which kind of reminds me of another scenario years ago where the subordinate employees were engaging in some fairly gross harassment and horseplay and grabbing and all sorts of stupid things in the workplace. And you're going, where are the managers? Where are the supervisors? How could all this happen? Well, it turned out the manager and his co-manager were smokers, and they were always out on smoke breaks. Not always, but you know, they were out smoking a lot. And so they were outside, they were away from the building as their subordinate employees were engaging in all of this inappropriate behavior. They weren't there, they didn't even know what was going on. So the notion of accountability of managers and supervisors is really critical. The EEOC, of course, recommends that where you find problems, that they be immediately addressed and corrected. And this notion that, oh, it's not that bad of conduct, it's just, you know, boys being boys or girls being girls, or, you know, this is just the way it is. And it's like that kind of tolerance can allow those types of behavior to become more egregious. And it really does sound like, I don't want to just beat up on Fox, although, you know. It does sound like the more you read about that workplace, that Mr. Ailes' behavior was well known to a lot of people. And not only was it well known, but it was sort of, it's again that fish rots from the head notion that others copy that behavior, or others treated, in this case, women, in the same way, because that's how the top of the organization That's the behavior that the top of the organization was engaging in. There was never an addressing or correction of those problems, and they probably just grew over for many, many years, it appears. On the topic of training, so ironically, the EEOC saying there's no evidence that training is effective, then they tell you how to have effective training. And frankly, I don't see that much that is new or very different, but they do start with having a good policy and set of procedures. And on page 4, these are some of the concepts. And I have looked at the non-harassment policies of many of your companies. We've reviewed, revised them over the years, and so I know that you have these good things that you should have in a policy. There's a clear statement of what is prohibited. There are details about how to make a complaint, giving employees multiple options. If the person who is managing you is the harasser, then you have other alternatives. You have some human resources avenue, you have, in some cases, a board of directors. And so there are multiple ways in which to make a complaint, which is what the EEOC recommends. Every policy I have seen, if it didn't have it when I first saw it, it had it when it left this office, has a non-retaliation statement in it. People cannot be retaliated against for having reported a harassment concern under the policy, even if it turns out that the harassment may have been just a misunderstanding. It's not a federal case, it's not a terminable offense, but that person is not retaliated against for having used that process under the policy. The EEOC also recommends having an investigative procedure under policies, and that is appropriate and proportionate. And by that, I mean that not all concerns, complaints, gripes may warrant hiring, for example, an outside investigator who comes into your organization. Most organizations have some kind of internal mechanism through HR or some other office that can address and investigate and get to the bottom of some of these problems. And some of these can be quickly resolved because they're either misunderstandings or there's something that can quickly be stopped. And so, again, the policies I've seen do have those provisions of some kind of investigative procedure. There is some statement, there should be a statement in a policy that it's not just, we really don't want you to do this. There should be a statement that we don't want you to do this, you are prohibited from doing this, and if you do, things will happen, bad things will happen to you, some type of discipline, depending on the nature of the conduct. And that discipline should be consistently applied. If one person engages in a certain type of harassment and they are terminated, then that kind of sets a stage for if similarly situated employees engage in similar conduct, they should also be terminated. So consistent application of those disciplinary procedures. Then you get to the training, and the EEOC, again, having said, well, we don't think training seems to be effective, they then say, here are some things that can serve to make the training more effective perhaps. First of all, training mid-level managers, again, making sure that you're not just requiring the rank and file employees to undergo this training. It really starts with the top management, and it starts with a commitment from the organization. I did some training years ago by someone who owned the company, and he hired my firm, and we went in there, and the training started out with his commitment. The owner of the organization that had a few hundred employees at the time standing up at the front of the room and saying, this is going to be our policy and we are going to follow the non-harassment policy, and you're going to get trained on this, and, you know, really making that statement of commitment from the top of the organization, that it's not just this policy that everyone, you know, welcome new employee, here's your set of policies, please sign off, you know, and everyone signs everything. It's more than that, it's just a commitment to prevent these types of problems. And this organization where I was doing the training had some harassment complaints and concerns. They had a pretty good policy, but the message seemed not to have gotten through to some employees that the policy was something that everyone was required to follow. So as part of a training, it's really, and maybe that's where this holistic notion comes in again, that it's really the entire organization that is committed to this process. It's not just this, oh yeah, God, it's time again for, you know, our annual non-harassment program. It's more like this is an ongoing commitment to prevent problems like this in the workforce. And you know, on the subject of harassment, by the way, I always say that you can, you know, there are the overly hypersensitive employees who take offense at everything. And the things that they may take offense at are not even remotely prohibited under a non-harassment policy. But does that mean that you ignore those hypersensitive employees? And the answer is, of course, no, you do not. But they are counseled, I think, as to what is actually prohibited under the policy and what is not prohibited. There's also this fear of some employers, I think, when you're talking about non-harassment training, and I've actually had clients say this, it's like, well, if we train people, they're just gonna make complaints. And I get that, but there should never be a lack of knowledge or understanding on the part of your employees as to what is and is not allowed in the workplace. And there should never be a lack of knowledge or understanding as to how to address those concerns. Even those concerns may not rise to the level of, you know, a federal case, an EEOC charge. If they're sufficient to be really bothering an employee and interfering with his or her work, they should be addressed under the policy. And all of that should be part of the training. I've done training for financial institutions, and I've seen this light go off sometimes when you're talking about tellers in a financial institution, and you say, under the sexual harassment policy or the non-harassment policy, you don't have to put up with this kind of behavior from depositors. And they kind of go, wow, really? You know, like, I thought the customer was always right, and we just had to. And so that's one of the areas in which you realize that employees maybe haven't been brought to a level of understanding of how the policy is set out to protect them and the actions from which the policy protects them. And so, you know, there may be other circumstances where you realize that employees may think, oh, well, I don't think this is covered from, you know, this is covered by our non-harassment policy because this is a really important customer or this is a really important client. That notion, of course, that non-harassment policies protect people from supervisors, managers, owners, co-workers, vendors, visitors, clients, others who come into the workplace. And that's just an example of the type of conduct you want to make sure that people understand that the policy covers and that the policy protects them from that type of behavior. And then just one final note. Think about the fact that there is no one-size-fits-all notion for training. Just like the financial institution example I gave, the training should be tailored for your workforce, for your work sites, for your workplaces. And I think that's one of the reasons why some of the online or the video training may not be effective, because it's not really tailored for your workforce. So, finally, one point. You know, I attached some checklists, so you could kind of like detach these, save the checklists, and the rest of this material, I'll refer to you for your leisure time reading. But these checklists issued by the EEOC are really useful on looking at your reporting system, looking at your training system, looking at your policy, and just seeing what elements are in those aspects of your workforce. Okay, I'm going to turn it over to Quentin, and he'll talk about wage and hour.
Good afternoon. My name's Quentin Smith, and I'm an attorney with the firm. I know maybe half of you. I'm going to make a quick plug for the firm before I get started, because I was told to do this at the end, but I'm going to be running through a lot of material. So Barbara and I do employment and labor, well, mostly employment law. I do, probably 90% of my practice is devoted to litigation. I represent employers in a wide variety of things that employers can be sued for, but we also do counseling for lots of clients on compliance issues, things like FLSA audits, internal investigations, anything that is an employee issue that sort of bubbles up, we can help you out on. There's other folks in the firm that do construction law. I know many of y'all are not construction law, but if you ever have construction issues, have a new building or something like that, we have construction law. And we also have attorneys that do business type law. I can't explain all that they do, but they advise on licensing, regulations, business formation, those types of things. So I'll jump into the FLSA stuff. It's probably one of the most significant regulatory things that's happened related to wage and hour in decades. The Department of Labor issued its new overtime regulations, which are going to go into effect on December 1st of 2016. I just did an expert roundtable thing with the Albuquerque Business First. Y'all see that coming out soon. One of the questions they asked is, right off the bat, is there any chance this isn't going into effect? I would say no. You may hear things in the news about Congress proposing bills to try to block the regulations. The thing to keep in mind is that President Obama any bill has to overcome a veto, and we don't have, there's not enough Democrats, not enough Republicans in Congress, frankly, to overcome a veto. So these regulations are going to go into effect on December 1st. I would also say, from a political process, there's been very little talk on the campaign trail, but I think that the Republican position would be that they're going to, they want to look at these regulations and maybe roll some of them back. I think if Hillary Clinton's elected president, you can sort of just see the regulations go through. At any rate, they're going to go into effect on December 1st, and a new president's not going to be inaugurated until the end of January, and sort of, I have a hard time imagining it's going to be sort of like once employers make changes that they have to make by December 1st, putting the genie back in the bottle and lowering salaries or converting people back to exempt. It's just going to be impossible to do, even if there are regulatory changes. So I think don't count on this not happening. I'm going to sort of breeze through really quickly, because y'all probably heard a lot about what the regulations do. I'm going to sort of break this into two parts. I'm going to give a real quick primer on what the regulations do, and then we'll talk about lots of different options for trying to comply with the regulations. The first most significant thing is that the regulations raise the minimum salary level for white-collar exemptions, those who qualify under the administrative, executive, or professional exemption. They increase from $455 a week to $913 a week. That's almost exactly double. So how did the Department of Labor get to that number? They didn't just pull it out of a hat. What they've done is they've indexed that number to the 40th percentile salary for salaried workers in the lowest wage region, which was the South. And so when they ran their numbers, that came out to $913 a week, which is $47,476 a year. Second thing that the regulations do is they raise the minimum salary level for highly compensated employees. Highly compensated employees are those who maybe meet some of the elements of the administrative exemption, but not all of them based on the duties test. But if you pay them enough, you can sort of forgive making them work lots of extra hours. And so they increased the minimum salary for highly compensated employees from $100,000 a year to $134,004 a year. Another thing that it does is, for the first time, is that the regulations allow for up to 10% of that salary threshold, that new $913 a week or $47,000 a year, to be met by non-discretionary bonuses, incentive pay, or commissions. So, in short, the way this would work is that if you have an employee who receives certain types of regularly scheduled bonuses or commissions, you can pay them slightly less than the salary basis, and then you make that up on a quarterly basis by paying them their commissions. So if you have a person who receives commissions, but they know they're going to receive a certain amount of commissions, you could pay them roughly $850 a week instead of the $913, so long as that difference is made up through commissions and other non-discretionary bonus payments that are paid at least quarterly. And finally, the most significant thing long-term and looking years down the road is maybe not the increase to the salary basis test, but for the first time ever, the Department of Labor has built in automatic increases. In the way it's worked in the past is the Department of Labor says, okay, here's the new salary threshold. So back in 2004, they said the new salary threshold was $455, and then over time, inflation comes up and that number gets lower and lower and lower in terms of what Congress, or what the Department of Labor intends for the salary basis test. And so now, for the first time ever, they're going to automatically index that to the 40th percentile for salaried workers in the lowest earning wage region. So the minimum salary is going to automatically go up on January 1st, 2020. The Department of Labor is going to issue a notice on August 1st of 2019, 150 days in advance of the new rate, about what that rate's going to be. The Department of Labor estimates that that's going to go up from $47,474 to slightly over $51,000 in 2020. I frankly wouldn't be surprised if it goes even higher than that, because if you think about this, I saw in the newspaper this morning that for the first time since 2007, median wages have gone up. And so we're already seeing wages go up as the economy goes up, which is automatically going to drive up the salary basis test. And the other thing is that when we say that we're setting it, indexing it to the 40th percentile for lowest wages, we're artificially raising the floor, which is going to automatically raise that 40th percentile every 3 years. So you're going to see that number go up and up and up on a 3-year basis. So what did the regulations not do? The regulations did not touch the duties test. If you have employees who are properly classified as exempt under the white-collar exemptions, the administrative, executive, or professional exemption, if they meet the duties test that was previously laid out, then they can still be classified as exempt so long as you comply with the new salary basis test. This was something that people were worried about because the Department of Labor said, solicited comments on the duties test. Should we consider, changing the duties test? Ultimately, they didn't touch that. But the one thing I would say, and perhaps sort of the silver lining that comes out of these regulations, is that the Department of Labor estimates that something like 35 to 40% of salaried exempt employees are improperly classified. So even for those employees who meet the new salary basis test, I would recommend that you consider looking sort of more globally at your department, at your employees, and for those who maybe are questionably classified as exempt based on the duties test, you have an opportunity when you're sort of adjusting lots of people's employees' pay and classifications and things like that to roll those misclassifications up in there, because that's always the biggest problem when I come in and do an audit for somebody and I say, I don't really think this person is properly classified as exempt because they don't meet the duties test, is, well, what do we do now? If we tell them that they've been misclassified, then they're going to question whether they should have been paid overtime. Are we sort of inviting a lawsuit? What do we do? I think that one of the things about these regulations is that they give you the opportunity to sort of say, we're doing everything, we're doing a sort of a wide audit of our entire workforce, and we're going to be making changes, and that those employees who've been misclassified before, if they're converted, it maybe not as much of a red flag of, hey, what about the last couple of years? They just sort of get rolled in with everybody else on those changes. So let's talk about some of the options for compliance. I'm going to kind of, I've listed 7 options in the materials. I'm going to sort of go through each of those, and I'm going to sort of break it into a framework that is, how does this option work? Who are the employees that are most likely to, that this could be used for? What types of employees? And then what are some of the pros and cons of this approach? Now the first obvious is, you know, we've got an employee who's classified as exempt before, and we believe that they're still exempt. We could just raise their salary up to the new threshold, up to, you know, they were making $42,000 before, we'll just bump them up to $47,474. We're in compliance, we're done. So what type of employees is that most likely to be consider sort of doing that for? Probably those that are already pretty close to the $47,474, you know, those in $43,000, $44,000, $45,000 range. They're already used to being exempt. It's not that much of an increase to bump those employees up. And so that's probably the easiest option administratively, to just say, this is how it is, we're going to give you your sort of annual raise, and we're going to bump you up to the new salary. What are the pros of this approach? Like I said, ease of implementation. You don't have to require these employees who are not used to tracking their time to now all of a sudden be recording time. Employee morale. I mean, people are going to be happy to get raises up to the new salary threshold. I think a lot of employees are going to sort of expect that if they're already close, and so they're going to be happy with that result. What are the downsides? Labor costs could increase significantly. Even if you've got, you know, employees at $40,000, you got 10 of those employees, all of a sudden you're adding $70,000 or more to your payroll that you didn't have before. So you sort of have to think globally. If I got lots of employees in this sort of situation, maybe this isn't the best option for handling that. I would say that sort of to counterbalance the other employee morale issue is that what do you do when you've got employees on sort of a scale? You know, you see this all the time where it's like, okay, you're a junior, let's say buyer, you know, your salary is $40,000, you're a mid-level, it's $50,000, and you're a senior, you're $60,000, and you've got sort of these graded tiers. Now all of a sudden you're bumping the junior buyer up to $48,000, and there's just not that much of a difference anymore, and you sort of feel compelled to sort of recreate that scale again at a higher, so it has sort of, could potentially have a ripple effect if you've got that sort of thing. And then probably the one thing that I would sort of consider about this as well is that you might just be kicking the can down the road if because of the automatic increases. If you've got somebody who's at $46,000, it might not be that big a deal to bump them up to $47,000 or $48,000 at this point, but you know those automatic increases are coming 3 years down the road. Are you prepared to pay this employee $51,000, $55,000, $56,000 if the new salary increase goes up? And so it might be easier now when employees know about the new FLSA regulations to say, okay, we're going to go ahead and convert some of these people to non-exempt positions or do something else with them, because it's just going to be that much harder